I think it's a terrible decision. I think it's absolutely wrong on the merits. But going forward, I think this could actually be a blessing in disguise because it gives Jack Smith an opportunity to appeal the case immediately. So many of these other decisions were within the judge's discretion as she was slow walking the case. But this is one where it's immediately appealable. And I think she is so clearly wrong on the law that the 11th Circuit will reverse. Now, Donald Trump probably goes to the Supreme Court, and we have to wait for a decision there.
Trump's classified documents case just blew up in court after previously sealed materials were suddenly pushed into public view. The defense team, which had spent months trying to keep those files buried, appeared to lose control the moment the judge ordered them released. According to the script, Trump's lawyers began shouting at the federal judge, forcing the court to repeatedly restore order as the documents they had fought hardest to hide became part of the public record. In one explosive hearing, the entire containment strategy that had protected Trump's defense from public scrutiny started falling apart. Now let's look at why this case is much bigger than a simple paperwork dispute.
At Mar-a-Lago, many of them just packed haphazardly in boxes stacked in a bathroom. So the public will never know what kinds of documents were there. We had some sense from our reporting, but won't know the full extent because Judge Cannon has decided the report cannot be made public. And this was something that Trump asked for, his Justice Department agreed with, and now the judge that he appointed has affirmed.
This was not some small courtroom dispute or a technical legal argument. This was the classified documents case, the one built around allegations that Trump left the White House with boxes of sensitive government material, including classified records, intelligence documents, and national security secrets. These were not harmless papers or sentimental keepsakes. These were materials that, under federal law, belonged in secure government custody. And now, after one major ruling, the evidence Trump's lawyers wanted hidden was suddenly exposed to the public.
We learned of a Trump lawyer testifying back in December in front of a special counsel grand jury. What is that investigation about?
What we're learning is that Trump lawyers across the board are being asked about former President Trump's conduct when it comes to classified records, sometimes about his election conduct, because there's a belief in different prosecutorial realms that lawyers have more information. They're privy to private deliberations that could provide a real prism into whether Trump had the intent to commit a crime, whether it was obstruction, handling classified materials in an inappropriate way.
From the very beginning, Trump's legal team seemed focused on one goal: keep everything contained, keep the evidence sealed, keep the testimony confidential, keep the public from seeing the full picture of what prosecutors had gathered. As long as those records remained locked away, Trump's team could shape the narrative. They could call the case political persecution, insist the evidence was weak, and tell supporters that there was nothing serious behind the charges. But once the judge ordered the files unsealed, that strategy collapsed almost instantly. Now watch how the courtroom reportedly turned chaotic once the files became public.
From the former president's Florida estate revealed 48 folders marked as classified that were found empty. Some legal experts say that likely alarms investigators.
The government is under an obligation to find out where are those documents? Who has seen those documents? Where are they now?
In all, the list shows Trump possessed 103 documents marked as classified. 27 that were marked top secret, secret, or confidential were found in his personal office at Mar-a-Lago. 76 more were seized from his storage room.
The moment those files entered the public record, the courtroom reportedly turned chaotic. Video and reports of the hearing spread across the internet, with millions watching clips of Trump's attorney losing composure in front of the judge. What began as a legal argument reportedly turned into an angry confrontation, with the defense accusing prosecutors of ambush tactics and claiming the proceeding was unfair. Papers shuffled, lawyers whispered, the defense table scrambled, and the courtroom atmosphere shifted from controlled litigation to visible panic. Here is why the unsealed materials are so damaging for Trump's defense.
I personally approved the decision to seek a search warrant in this matter.
Trump accused of illegally keeping more than 300 highly classified documents and committing obstruction by not returning them as required under federal law. He pleaded not guilty. The trial in Florida is scheduled for May 20th, but that date is expected to be pushed back.
The reason this matters is because the unsealed materials are not easy to spin away. According to the script, the files include grand jury testimony, sworn statements, and evidence from people close to Trump. These are not random political enemies or outside commentators. They include advisors, staff members, associates, and former legal representatives who were close enough to witness decisions and conversations firsthand. Their testimony reportedly goes directly to what Trump knew, when he knew it, and what he chose to do after being told the classified materials had to be returned. Now let's see how the hearing reportedly shifted from legal argument into panic.
Former president had been barred by the judge from making a closing argument, but he managed to do so anyway. His lawyer basically opened the door, and the former president just barged right through it and said, as you were just describing, that he's completely innocent, that these charges are trumped up, that they are bogus, that this is a political witch hunt against him. He also said that this was an attorney general who's simply trying to stop him from advancing politically. And the thing that was so striking about this is that, you know, we think of courtrooms, no matter how adversarial they get, that there's a deference and a respect for the judge. And here was the former president directly attacking the judge to his face, saying that he had an agenda of his own, that he couldn't listen to anything for longer than a minute.
Inside the courtroom, Trump's attorney reportedly rose to challenge the judge, but the argument quickly escalated. The lawyer accused the prosecution of unfair conduct and suggested the entire process had become fundamentally unjust. But the more the attorney shouted, the worse the optics became. Trump sat at the defense table watching the legal shield around him crack in real time, while other members of the defense team tried to calm the situation. By then, the damage was already unfolding in public. This next part shows why the judge's reaction mattered so much. The judge responded forcefully, bringing the gavel down and demanding order. Witnesses described the scene as the collapse of a defense strategy that had taken months to build. And that description makes sense because this was not only about a lawyer losing control, it was about evidence. The unsealed files reportedly established timelines, conversations, warnings, and decisions. They show when Trump was told to return the documents, what he allegedly understood about them, and how he responded. That cuts directly into any defense built around confusion, misunderstanding, or innocent mistake. Now watch why testimony from Trump's own circle makes this case more dangerous. The witnesses named in those records make the situation even more damaging. These were people from Trump's own orbit, people who worked with him, stood near him, handled matters around him, and had strong reasons to avoid hurting him if they could. But under oath, they reportedly described what they saw. Their testimony allegedly includes details about Trump personally sorting through boxes, discussing classified material, resisting return efforts, and showing sensitive documents to people who did not have proper security clearance. If that evidence survives legal challenge, it becomes extremely difficult for the defense to explain away. Here is why the timing could not be worse for Trump politically. The timing could not be worse for Trump. His lawyers are now trying to handle the fallout from the hearing while the unsealed files are being downloaded, quoted, analyzed, clipped, and shared across media platforms. At the same time, Trump is trying to function politically, manage his public image, and maintain credibility. But now the news cycle includes footage of his lawyer shouting at a federal judge and reports that sworn testimony from Trump's own circle undermines his defense. That is not an easy image to erase. Now let's see why this hearing changed the whole public narrative around the case. The visual damage is serious, but the substance is worse. The public can now examine material that the defense worked hard to suppress. Prosecutors can point to evidence that reportedly shows Trump's knowledge and intent. Legal analysts can break down the testimony and explain why the case may be stronger than Trump's team wanted people to believe. The defense can no longer keep the strongest material hidden while claiming the prosecution has nothing. The documents are now part of the public conversation. Some people may try to dismiss this as just another Trump legal controversy, another headline that will fade after a few days. But this moment is different because it is not built only on political argument. These are court records. This is sworn testimony. This is material prosecutors spent months gathering and that a federal judge allowed into the public record. That makes it harder to dismiss as noise. Trump's lawyers knew what was in those files, which is exactly why they fought to keep them sealed. Their reaction when the documents were released speaks volumes. Once evidence enters the public record, it cannot simply be pulled back. The country cannot unsee grand jury testimony. The press cannot ignore court documents that are now available. The defense cannot pretend the material does not exist just because it damages their strategy. That is why the hearing was so important. Trump's team lost control of the courtroom, but more importantly, they lost control of the story. To understand why this moment hit so hard, you have to go back to the beginning. The case traces back to January 2021 when Trump left the White House. Presidents are supposed to follow a clear legal process for official records. The National Archives receives presidential documents, classified materials, and government records. This is not optional. It exists to protect national security and preserve public records. But Trump allegedly directed boxes of documents to Mar-a-Lago instead. The key issue is what was inside those boxes. Prosecutors allege the materials included classified records, sensitive intelligence, and national security information. These are the kinds of documents that belong in secure government facilities, not in a private club where guests, staff, and visitors move through the property. The National Archives began requesting the materials. Some boxes were returned, but officials later concluded classified documents were still missing. What began as a records dispute became a criminal investigation. Then came the FBI search of Mar-a-Lago in 2022. Federal agents executed a court-approved warrant and recovered classified documents from Trump's property. Trump immediately called it a witch hunt and claimed the search was political persecution. But the central problem for that narrative was that the documents existed. Investigators found classified materials, including records with serious classification markings and reportedly sensitive information involving national security. That evidence led to criminal charges. The prosecution's case centers on whether Trump unlawfully kept classified documents after leaving office, whether he obstructed efforts to retrieve them, and whether he showed classified material to people who were not authorized to see it. For months, Trump's lawyers filed motions, sought delays, challenged procedures, and fought to keep key evidence sealed. But the prosecution eventually pushed for transparency, arguing that the public had a right to understand the evidence and that continued sealing served Trump more than national security. The judge agreed, and that decision detonated the case. The unsealed records reportedly include grand jury testimony from people close to Trump, including aides, staffers, associates, and even former attorneys involved in earlier phases of the investigation. Some of that testimony may have become available because of the crime fraud exception, a legal doctrine that can pierce attorney-client privilege when a judge believes legal advice may have been used in furtherance of a crime. That is a serious development because attorney-client privilege is one of the strongest protections in American law. For Trump's current defense team, this had to be devastating. They built a strategy around keeping damaging testimony out of public view. Then suddenly, testimony from people inside Trump's own world, possibly even from former legal counsel, became public. That is the kind of moment that can destroy months of careful legal planning. It explains why the hearing reportedly turned into chaos and why the defense reacted with such visible anger. To be clear, this does not prove Trump guilty. That decision belongs to a jury after evidence is presented in court. But it does mean Trump's defense now faces a much more difficult road. The damaging information is not coming from anonymous critics. It is coming from people who worked with Trump, advised him, and witnessed events directly. Prosecutors can use that testimony to argue that Trump knew what he had, understood that the government wanted the documents back, and still chose not to comply. That is what separates this case from ordinary political noise. Physical documents recovered from Mar-a-Lago were already serious. But witness testimony from Trump's inner circle adds a powerful layer because it can establish knowledge, intent, and behavior. It can show what was said, what was understood, and what choices were made. Those are often the details that separate careless handling from criminal conduct. The judge's reaction also adds weight. According to reports from inside the courtroom, the judge appeared furious with Trump's legal team and confronted them over their arguments about why the evidence should remain sealed. There were suggestions that the defense had misled the court or failed to be fully honest about the nature of the evidence. A judicial rebuke like that can follow a legal team into every future hearing. Once a judge questions a defense team's credibility, every argument they make afterward faces greater scrutiny. Trump's current position makes the whole situation even more extraordinary. In this script's framing, he is not just a former president quietly fighting a private legal battle. He is sitting in the Oval Office while this case unfolds publicly. He is trying to govern, manage international issues, push policy, and maintain political support, while his lawyers are melting down in court and classified document evidence is spreading online. That creates a credibility problem that cannot be solved with one social media post. Politically, the fallout is obvious. Opponents will use the unsealed testimony in ads, speeches, hearings, and media appearances. Trump's allies will call the case unfair, biased, or politically motivated, but that defense becomes harder when the evidence includes sworn testimony from people close to Trump himself. His core supporters may remain loyal, but independent voters, moderates, and Republicans exhausted by endless legal drama may view this as another sign that the chaos is too much. Legally, the case has entered a new phase. Prosecutors can now shape their public and courtroom narrative around testimony that is already out in the open. They can build timelines, call witnesses, introduce documents, and argue that Trump's actions were deliberate rather than accidental. The defense will still fight hard. They will challenge credibility, question interpretations, argue context, and insist the evidence does not prove criminal intent. But the unsealed files make that job far harder because they give the prosecution specific details and witnesses to work with. The larger questions go far beyond Trump personally. How should classified information be handled by presidents after they leave office? How far does presidential power extend? Can a president be held criminally accountable for conduct involving government secrets? What happens if a sitting president faces trial or conviction? These are not small questions. This case could shape future rules, future investigations, and future expectations for presidents handling sensitive information. What happened in that courtroom was not just viral drama. It was the moment a defense strategy ran into evidence it could no longer control. The documents Trump's team fought to keep hidden are now public. The testimony they wanted sealed can now be examined. The narrative they tried to manage is now outside their hands. And whatever happens next, the case has changed permanently. There is no going back to the old strategy because the secret files have already seen daylight.